So let's have a conversation around how leases come to an end. And I think that's maybe the best way to describe it. How does a lease come to an end? Now, there's numerous ways that a lease can come to an end. The one that we most commonly get asked about as attorneys, obviously, is when somebody does something wrong, like the tenant doesn't pay rent, then the lease is cancelled, right? But there's other ways that a lease comes to an end. For example, maybe the time runs out in a lease and it's time for the tenant to move out. That's another way a lease comes to an end. A lease may also come to an end. Month-to-month leases may come to an end if a person gives that month notice requesting that the tenant move out, or the tenant gives a month's notice advising the landlord that he or she is going to move out. So these are all different ways that leases may come to an end. And now, going into slightly more detail, some of the confusion around the 30-day notice versus 7-day notice, like which notice must I give? It comes again around the fact that some leases are running on a month-to-month basis. And even if the tenant fails to pay rent, and this is more often than not when it arises, on a month-to-month basis, the tenant fails to pay rent. And some of the questions come up going, but what do I do? What notice do I give him? Effectively, it's the same thing, right? Now, you can place him on terms, and you can send out a notice placing him on terms. Remember, in terms of the Consumer Protection Act, you normally give 20 business days notice requesting that the tenant rectify a breach before you're able to actually cancel the lease agreement. But on a month-to-month lease agreement, if you're sending out a 20 business day notice, or you're just giving the tenant notice that he needs to move out the property at the end of that 1 month period, it is pretty much the same thing. So you might actually just want to focus on the time calculations to make sure that it works for you. But if you actually want the tenant to remedy the breach and you want him to pay, in that instance, send out the breach notice, because then once he pays, the lease continues. If you'd rather terminate the lease and you've had it with this tenant and you want to give him notice for him to move out, then send out the 1 month notice and advise him that the lease is terminating and that he has to vacate the property at the end of that 1 calendar month notice. This does not impact your rights to claim the rent from the tenant. So either way, you can claim the rent from the tenant. You're just choosing by which mechanism you're bringing this contract to an end. So that's one thing to remember. Remember, CPA does typically apply to most lease agreements because landlords that have investment properties are considered to be carrying on a business. There are exceptions to this rule, but I think it's maybe 2%. So it's not something that we can delve into. But we've seen a couple of exceptions. Somebody temporarily moved abroad and rented out their property. That was one exception. And for example, if you're renting out to family members and it's not really in the course of trade, you might be able to not have to send the notice in terms of the Consumer Protection Act. I hope that answers that question.
So yeah, thank you very much, Bruno.